Good morning, Ms. Cowen. I think somebody must help you so that we can hear with the mic there.
Good morning, Acting Chief Justice.
Good morning.
Good morning, Commissioners.
Good morning. Two things that I want to say before we start. One, I want to encourage everybody to be masked especially when they are not speaking. Thanks to Commissioner Tsepe, who said she would make sure I'm reminded of that. Two, I've been advised that Ms. Cowen said that because of allergy, she might cough from time to time. Nobody needs to be concerned, she's fine. So well, she looks fine to me.
I'm happy to wear a mask if you prefer, Chief Justice.
Okay, all right. No, let's start. Ms. Cowen, I see that your academic qualifications are BA, LLB, and BCL, is that right?
That's correct.
Yes, and you got them in 1992, 1994, and 99 respectively.
That's correct.
Yes, and when were you admitted as an advocate?
That would be 2000.
That would be 2000.
Yes, the end of 2000.
And would that be at the Johannesburg Bar?
It was at in the Johannesburg High Court, yes.
Yes, and you have practiced at the Johannesburg Bar?
At that stage, I was clerking at the Constitutional Court.
Yes.
And I was admitted before I then started pupillage, which I started in Cape Town.
Yes.
And then I came back to Johannesburg in 2010.
Yes. And you actually started practicing from when?
From 2001, I did my pupillage. Started practicing from July 2001.
Yes, and you have been in practice throughout without any interruption.
That's correct. Yes. I took a short sabbatical to write a paper on judicial selection.
Yes. Was that because you knew one day you would be here?
It was a very humbling experience.
And tell us about your practice, the nature of your practice, the types of matters that you have been doing.
Well, I suppose, thank you, Chief Justice. I think I've had probably the best way to describe my practice is that I've got a general civil practice. I have had some criminal law exposure, but the focus has most certainly been in the civil context. Within the civil context, I've had a very wide range of experience. So I've been drawn into matters of various different procedural types. So I've worked in the trial context, I've worked in the motion context, I've worked on appeals, I've worked in multiple areas of law. So constitutional law has always been a theme, and administrative law has always been a dominant feature of my practice. But I've been exposed to multiple areas. So customary laws come up, land law, gender issues have come up, commercial law, delect contract. I've been exposed to a very wide array of civil matters.
Yes, and today you and then in terms of different branches of law, you have said it's constitutional law, your practice included it included admin law and criminal law as well?
Criminal law to a limited extent.
Yes.
Would you like me to elaborate?
Yes.
So when I started my practice, well, let me start a little bit before I came into practice. So when I studied, when I did my postgraduate degree, I chose to pursue coursework in the law of evidence at tertiary level. And my interest there was really to get a good grasp of the procedure of the principles of evidence in both, and that obviously applies in both the criminal and the civil context. So that was a feature of my study. And then obviously when I was at the Constitutional Court, there were issues that came up in criminal law. So I think at that stage, there were still cases around reverse onus. Those were important, and the bail decision had come down not that long ago. And so the Constitutional Court was grappling at that stage with some important features of how the Constitution impacts on criminal law, criminal procedure in particular, and evidence. And then in practice, when I started in the Cape, I did, at that stage, there was a process whereby you would make yourself available to do pro deo work. And I did some of that, which exposed me to criminal matters and took me into the criminal courts. I was asked to be an assessor in a criminal trial quite early in my practice, which I did. That was a murder trial. And then my practice, then the civil work dominated for a period. But I've come back into criminal law in limited ways, but I think they're important ways. So the one would be through the regulatory context. There's always an interplay between the regulatory world and criminal law, because usually there are criminal sanctions to breach of regulatory rules. So one has to be very cautious when advising and litigating in that area to ensure that your client's interests are protected or properly protected in that context, because there's often that a quick jump between breach of a regulatory provision and potential criminal sanction. So I've engaged with that a lot, and I've also had exposure as an acting judge to contempt matters. Contempt matters have come before me, certainly not of the sort that has been confronting our apex court of late, but I have dealt with contempt matters on several occasions at this stage. I've also was involved, I think, in asset forfeiture, done some asset forfeiture work.
And you have acted in the High Court a few times?
I have, yes, I have.
How many times?
Well, the first stint that I did was in the High Court, so I was invited to act in the Johannesburg court.
Yes.
And I did a 4-week stint, that I think was in 2018. And then in 2019...
How long was that stint?
I think it was 4 weeks.
Yeah.
It was 4 weeks. And then in 2019, I volunteered a pro bono week, which I think I did oppose motions that week. And then in 2020... Since 2020, I've been in the land claims court for 6 months of each year. In this year, both 2020 and 2021. And that entails secondments, or we get brought back into the High Court for periods in each stint. So during the course of that, those stints, which have been each of them is a term at a time, I will go to the High Court and do duty as required of me. I've been to both Pretoria and Johannesburg. So I think in total at this stage I've spent 14 weeks in the High Court and 35 land claims court, and I've just started. I took the oath twice yesterday.
Okay, all right. Judge President Lambo.
Thank you, Acting Chief Justice. Advocate Cowen, I just want you to tell the Commission what heavy lifting work you've done when you acted in Gauteng.
What is the nature of my allocations?
Yeah.
Thank you, JP. Morning.
Morning.
My allocations have been quite varied. I haven't covered the full gamut, but I've done a varied work. So I've quite frequently been allocated to the opposed motion court. So I've done that a lot, which I think accounts for the number of my judgments. I've also been in the civil trials court, both the general civil trials court, and I've run a full civil trial in the general civil trial in the Johannesburg High Court, but also plenty of the RAF matters and the medical negligence matters that come to court on a regular basis. I've done those. And then I've done appeals, civil appeals. I've indicated my interest in doing criminal appeals, as you know, Chief JP, and I've done quite a lot of the work that's involved in case management. So as you will know, and as many commissioners will know, that there are multiple courts in the multiple courts that are convened in the High Court, which are designed to ensure the effective management of matters such as RAF and settlement and case management. And I've quite frequently been allocated to that role. So I'm familiar with that.
Okay. My last question, Acting Chief Justice, is these work areas, and you can tell the Commission which one ties in a lot with the work you do in the Land Claims Court. If you look at the nature of the work you do there.
In the High Court?
Yeah. No, in the Land Claims Court, if you look at the allocations in the High Court.
Yes.
Yes.
Which tie together.
Yeah.
Well, I think they tie together in multiple ways, in fact. Yes. What I've seen is, the obvious cases, the clear case is eviction work. So their evictions come to both the High Court and the Land Claims Court. So I've dealt with evictions both through the lens of PI and through the lens of Esther and the Labour Tenancy Act. And so that's a key point of overlap. In the High Court, I've engaged with property law matters in multiple ways. So they're not the type of matters that one will think about when one thinks about land justice necessarily, but you do see multiple property disputes. So I have thought about, I'm familiar both from practice and adjudication with dealing with property law at a conceptual level. And then obviously the foreclosures, where foreclosures is I find it a very sad feature of our high courts. There are many foreclosures that come to the courts, and I've dealt with those. We have to deal with them, and that exposes the vulnerability of people within the urban context, typically, to losing their homes, to being unable to pay their mortgages. So I've dealt with that a lot. And that there's overlap. And if I may just add to that, it's also issues like trust law and company law. There's overlaps there, because what you see in the Land Claims Court is that even though we only vested with jurisdiction at this stage, with jurisdiction over 3 statutes, there are also, you need to be able to grapple with other issues like trust law, company law, and procedural law. Obviously, you need to have a good grasp of both the adversarial and the inquisitorial process. So I think I've had a fair exposure on both of those. Okay.
I thought you'll mention case management as well, because I thought there's a lot of case management in the Land Claims Court.
Yes.
Okay.
I think it's a terribly important issue. Yes.
Okay. Thank you, Acting Chief Justice.
Indicated my interest in doing.
Thank you, Judge President.
Criminal appeals.
Judge President.
As you know, Chief JP.
Good morning, Ms. Cowen.
Good morning, JP.
Let me take off my mask.
Focusing more specifically on issues relating to restitution and land tenure security and a whole range of other issues that have disputes that affect rural people. So in that space, in the context of my legal resources centre work, I was exposed to quite a lot of work of that nature. And that took me also out of my office and into rural areas, which has given me insight that I wouldn't have otherwise had, I don't think. So I've worked directly in communities such as in the Northwest Province, the Bakatla-Bakafela communities, and in the Bafokeng communities. And I've worked in the Eastern Cape, in the Mgungundlovu community, which is on the border of KZN and Eastern Cape. And I've had access, I've had clients in other areas as well. So that's been very important for me. So just to then focus on the question you also asked, why do I consider myself to be well placed? Well, I think I consider myself, well, let me first say, I think it's a privilege to serve. I think it's a privilege and a heavy responsibility to serve as a judge. But I do think that I bring the skills that are needed, and I do think I have a unique combination of skills that the Land Claims Court can benefit from. So I would highlight my experience in the various contexts which I've referred to. I'd highlight my understanding of, or my exposure. I wouldn't claim a full understanding, but my exposure directly to rural communities that are affected by land reform. And I would also highlight my practical experience in the Land Claims Court itself and the High Court, where I've spent quite a lot of time trying to give life to the injunctions in the Land Claims Court around procedure. And I'd like to highlight three. The one would be mediation. I think mediation plays a critical role in the land context. The second would be case management, which the JP has raised. In the Land Claims Court, that means that we have to actively monitor cases to ensure they're expeditious, cost-effective, and efficient resolution. And that's a different role to what you play in the High Court. And then also the inquisitorial features of that court. So I've grappled with those, and I enjoy working with them, and I think they can play a very useful role in resolving some of our challenges.
Just remember, Ms. Cowen, that although Judge President may be the one asking you, you are addressing all of the commissioners.
My apologies.
Yeah, you want them to understand your knowledge of the relevant areas of the law and your experience. So although she might be asking questions, remember that you are addressing all of them.
Thank you, Chief Justice.
Okay.
Acting Chief Justice, I have just one more quick question.
Yes.
I'd like to hear from you if you have any ideas about how the Land Claims Court can be strengthened. We have the introduction of a land court bill, which we hope will soon become an act. So do you have any thoughts about that sphere?
Thank you, AJP, Chief Justice. I do have thoughts about it. And of course, I'm mindful of the fact that the land bill is still before Parliament, and that Parliament might choose a different direction to what the Minister has placed before it. So that legislative process must take its course. But I'm very pleased to see that there is a political commitment to strengthening the court. I think however that debate plays out, I think that's critically important. I would like us to think ambitiously, practically, and in a way that builds on what we already have. When I say we should think ambitiously, I have ideas. I don't know how realistic they are, but I think we should be having a conversation about whether we want to build on the existing land court and create it as more of a symbolic space that people feel able to access as a symbol of access to land justice. And what I have in mind, I realize there are funding implications, but the Constitutional Court has become such a symbolic site in our country of access to justice. And I wonder whether we shouldn't be thinking about our land court in similar, possibly less ambitious, but in similar ways. I think we should be thinking about the place of Indigenous languages in that court, and mindful of the recent injunctions of the Constitutional Court around the importance of elevating the status of Indigenous languages in commerce and law, in areas where English remains dominant. I think we should think carefully about that. The practical issues, things like, I've mentioned a couple of them, I think we should build on what we already have. So issues like mediation, I think are fundamental to resolving land disputes efficiently and economically. But I don't believe that the capacity is currently there to do it effectively. So I think we need to build that up. Things like case management, I think we need to build on that. Things like access to justice. The Land Claims Court has made enormous strides in that area. And I think we need to look at what it's done and understand where it's failed and build on those as well. And I can see many opportunities for doing that. So I do have ideas. They may not all be practical or immediately realizable, but I do think we should be thinking ambitiously about the court. Thank you.
Thank you. Are you done, Judge President? Are you done with your
questions?
questions?
I'm done. Thank you.
Okay, all right. Commissioners, any minister?
Yeah, thank you, Acting CJ, and good morning, Acting Judge.
Good morning, Minister.
Thank you. I just want to start where you ended now, about us thinking ambitiously about the court. One of the considerations we had to make in terms, you have said we are currently dealing with 3 statutes. You will have seen that in the bill we have listed, I think, about 10 of them that we are looking to start with the court. But our worry was that we may burden the court to the extent that with all those legislations, it might not even be able to even start. So as we become ambitious, we want to get from your ideas, how do we balance so that still the court becomes effective, there's access, there's expeditious resolutions of these disputes?
Thank you, Minister.
MEC Lesufi.
Oh,
May.
I'm sorry, I'm told he is supposed to be virtual. Oh, yeah.
Yes, I'm here, acting CJ.
Good morning, MEC.
Good morning, everyone. Acting
I'm
CJ,
sorry.
are you well?
Sorry.
no, I think the CJ was saying it should be MEC Lusufi after the.
No, okay, no, I'm
Shall I
sorry.
answer the Minister?
I think it's commissioners who try to draw my attention to their hands. Okay, let her answer, and then it will be MEC Lesufi after that. I'm terribly sorry.
Thank you.
No, it's okay.
I have to try and keep looking to see which hands are up.
Yes, I mean, I think obviously some of the issues that I've raised are not issues that we're not going to get from here to there immediately. I mean, I think that we need to accept. But, you know, as with all things in the progress of this country, we need to take one step at a time in the right direction. And we need to plan in a way that allows us to build on our existing strengths, face up to whatever weaknesses we may have, and build our institutions so that they can serve the goals of the Constitution. So I see it as we need to think big, but be very practical in the steps that we take, one by one. I think that's the way I'd frame it.
Okay. Yeah. The other issue is that I see from most of the cases, you have dealt with access to land by women, which is commendable and so forth. But I see that there are no cases that deals with the crux of the market value or calculation of the prices of the land, and also some of the cases that in terms of the Restitution Act, you could deal with the expropriation of some of the land. I know that it's obviously a role of the commission and the executive to bring some of those matters to yourself. What do you think should be done to ensure that those kind of matters do find their way to the court to help us to speedily resolve the land challenges in the country?
Thank you, Minister. Well, first let me say that I do have cases before me at the moment. So I'm case managing a couple of cases that do deal with those issues, and there is one that I'm currently seized with. There are a couple I'm currently seized with. But what do we do to ensure that those matters get to the court? Well, yes, I mean, the judges have, as a court, you have limited control over that, obviously. But I think there are things that you can do, and I've seen it in the cases that I'm managing, where once the court is vested with some form of jurisdiction. So let's take, for example, a matter that's been brought. Sometimes parties are trying to refer a matter to the court. The commission has failed to refer a matter, and then a party will raise the delay. Once the court seized of it in one way, there are ways in which you can use those case management powers to bring the matter more fully and comprehensively before the court, and then assert the duty that you have to ensure expeditious, cost-effective, and efficient resolution of the issue. But obviously it's limited. I'd also say, so I think we need to engage very actively in that case management duty as a judicial officer in that court. The second thing I'd say is that I think that we need to be perhaps less shy about what I would call constructive dialogue between the judiciary and other arms of government. There are challenges that we face. and we're only going to resolve them through constructive dialogue. Obviously, the way that dialogue has to take place has to be acutely mindful of the separation of powers, and the independence of the judiciary needs to be safeguarded. But I don't think that precludes constructive dialogue. So where there are challenges, I think we need to find ways that respect the separation of powers profoundly to have that conversation. So I think the special master case, the Mwelasi case, is an example, and I do understand that there have been challenges around that. And around giving effect to the order. But I think that gives us a model where we can start thinking about, well, are there ways that we can unblock things through constructive dialogue?
Thank you.
Thank you, Minister. MEC Lusufi, I'm told I should have started with you before the Minister.
No,
I apologize.
No.
I'll make sure
it's
for
okay.
the next
It's okay.
candidate. But I give you the chance now to ask the candidate.
It's okay, Acting Chief Justice. Good morning, and good morning to all commissioners. Good morning, Advocate Cowen.
Good morning, Commissioner Lesupi.
I hope you don't mind to share with us your expectations of utilizing the Land Claim Court as an enabler to resolve our land-related challenges, especially in a landlocked province like Gauteng. Do you mind to share us your expectations on utilizing that important court as an enabler to resolve long outstanding historic challenges that are related to land? Thank you.
Thank you, MEC. Well, first, as you were speaking, I was thinking the word enabler is a very useful word because it is cognizant, again, of the issue of separation of powers. One can do so much as a judge. You're sitting and you have to receive and adjudicate disputes. But it does, I think there are multiple ways in which we can serve that role. First, if I can just respond to the issue of Gauteng. Of course, Gauteng, and if I were to be recommended for appointment, I would be in the Gauteng High Court seconded to the Land Claims Court. The Land Claims Court works nationally, and even though we're based in Randburg, we're also itinerant, and we often leave the court and adjudicate in other spaces. So I think as the Land Claims Court, we need to think both provincially and understand the space, our place in Gauteng, but also think much more broadly and think nationally. But I think the concept of enabling is good. I think there are multiple ways. The one I've mentioned already, this idea of a constructive dialogue with the state, I think matters. I'd also mention, this is something I think about whilst I perform my duties as an acting judge in this court. I think that the way that we frame our jurisprudence, our case law, our reasoning, needs to give a very strong message to people who wish to utilize the court about how to do it, and it has to be, again, it's, I suppose, the idea of a constructive engagement also with your audience, being the not only your litigants, but other people who need to access the court. So you need to almost unlock what are quite difficult processes, and use your judgments as a way to engage with the public. So that's a way. I think another important feature would be for us to really think about access to justice within the rural context and in the urban context where land court issues are triggered. I think I've already addressed that in responding to an earlier question. I hope I've answered your question.
You did. Thank you so much, Advocate. Truly appreciate that. Thanks, ACJ. I'm covered. Thank you.
Thank you, MEC. Commissioner Matomsela. I just want to remind everybody that I'll be maybe stricter today than I was yesterday about the 40 minutes per candidate. And I think what's important is that we should cover the important areas that we need to look at: the candidates' integrity, candidates' knowledge of the relevant areas of the law, industry, and those other criteria. but I'm going to be stricter than I may have been yesterday. Okay.
Thank you, Acting Chief Justice. Good morning, Advocate Cowen.
Good morning, Commissioner Madonsela.
I just want to ask you whether you have any understanding of any African language or some familiarity with the African cultures. I ask this in the context of the gateway to land restitution claimed by communities, which has been closed for some heart in jurisprudence of the court in the definition of what a community means. And do you have any views about how that concept can be made flexible enough to allow communities to claim?
Commissioner Madonsela, I'm afraid I didn't hear the second part of your question properly.
Well,
I heard the first part of the question.
Well,
when
I was sneaking in the second question because we have one. Please focus on the first one.
All right. Thank you. As I understood your question, you asked me whether I have any familiarity. And the answer to that is yes. If you'd asked me the question, do I speak an African language, I would have answered the question no. Not in any meaningful way. So, as I sit here, I'm
Maybe
very
the word
mindful.
familiarity is a bit worse. Do you understand and speak any of the African
Not
language?
in any meaningful way. That's the answer to that question. And as far as culture is concerned, I think yes, I have more familiarity. Well, obviously, I think culture is such a broad context, but I have had, through my various dealings, through my various work, I've certainly tried to immerse myself in the various issues that I'm dealing with, in whatever context I'm operating.
I do want to follow up on this one. It's an important aspect.
Okay.
Which is linked to the question you didn't understand. The concept of community is largely dependent on the community or the group of people sharing rules which are embedded in their culture.
Yes.
And the reason why I asked your familiarity with the cultures of any African community is how will you be able to develop experience relating to land claims by communities if we have no better understanding of their cultures. That's what I would guess.
Thank you, Commissioner Madonsela. And may I just start my response by saying that I think that the issues that you raise are incredibly important. And I do think about them a fair amount. What I would say is that, well, firstly, I've grappled with the concept of community in multiple ways. And I've given quite a lot of thought, and I've had to deal with multiple instances where we have to understand how it is that a community is constituted, and how it is that the rights are being asserted. Perhaps I can give an example or two. The one would be, what's coming to mind is the case that I did in the Pilane case, where the Bafokeng case, where what we were dealing with in that case was systems of governance under customary law, and how it was at a narrow level, it was a dispute about how a community must authorize litigation. So typically, if you have a company, you'll have the company resolution and so on, and it's easy to prove and easy to establish. And what was at issue in that case was how, within a community context, and a large community context, where what you're dealing with is a land dispute that has its own dynamics in the community, how do you authorize litigation? And that is the subject of a judgment. And in the course of we had to deal with the evidence in that, and we, as the representatives that we were respondents in that case, what we had to do was try and understand features of Botswana custom, which look at how consensus seeking is achieved through the process of dialogue at various levels of the community. So there was a question around whether a decision could be taken at traditional council level or whether that had to be informed fully by a debate that took place at other levels of the community from the village level. And there was a principle that I came to understand in that process, which was explained as the principle of Kagiso, that in all of the engagements that take place, which is literally translated as I understand it, peace. And as I understand it, that historical customary governance processes in that community, and not only in that community, as I've subsequently understood, that the process of consensus seeking is important. It's not simply about taking majority decisions. It's about finding solutions to disputes, fundamental disputes like land matters, that engage people and try to find solutions that will engender a community cohesion. And so I have an understanding of that through my work. And I think the way I've approached it is that, I accept my limitations from where I come from. And what I try to do is to ask the right questions and to listen and to work very closely with the people whose interests are affected.
Well, in the interest of time, I will leave other commissioners to take this up. I would have liked to probe onto this, but we have constraints of time.
Yes, thank you. Commissioner Chape.
Acting Chief Justice, thank you and good morning. I think I'm covered.
You're covered.
I'll leave
Excellent.
it.
Yes. Then next will be Commissioner Dodovu.
Yes, just briefly. Acting CJ, good morning.
Good morning, Commissioner.
My question relates to your view on what is largely spoken about currently in the country, expropriation without compensation. What is your view on that? And in the current conjuncture, the current constitution, without seeking the amendments, do you think that it will be lawful to implement it without amending the constitution?
Thank you, Commissioner. Yes, and obviously I've been alive to those debates and I've followed them as they've ensued. I think that the way in which we approach, I need to distinguish between my views, personal views, and also my judicial views, and I need to be very cautious not to delve too deep into issues that are before me.
I'm thinking exactly about that. I'm thinking exactly about that because you don't know that there may be a case that comes afterwards and it might well come before her. So it's dangerous territory.
I'm happy to share my views at a high level.
Let's hear the high level.
I think what's important is that I avoid factual issues because what is critically important.
Well, the JP would just have to make sure he doesn't give you that case. Yeah.
Well, I feel comfortable speaking about it in part because I've dealt with cases in my practice. So in my own practice, and that's on public record. In my own practice, I have pursued a matter on the basis that no compensation should be paid in the context of those particular facts. And commissioners will understand what our ethical duties are as legal representatives when pursuing a matter. So I pursued that case on that basis. It was a very particular set of facts. The matter settled. So there's no benefit of jurisprudence from that particular case. But I do think that when we think about this, we need to differentiate between what's permitted by the Constitution. Obviously, I'd have to hear legal argument on it fully if the matter were to come before me squarely in those terms. The issue of nominal compensation seems to me to be quite clear. That a consideration of the various factors that are listed in the current section 25.3 can yield nominal compensation. I think that's clear. There's an easy case where if you consider a property of, I'm just thinking conceptually when you look at the factors, not thinking about facts, but all else being equal, if a property has market value of X and the state investment over time has been far in excess of the actual value of the property or the right. It may not be property. It may not be ownership. It could be a lease interest, for example. And I think certainly there are many commissioners here who will understand the history of under apartheid, the history whereby many people were given leases for almost no rental. It's extraordinary. When one starts looking at those leases, I could afford half of them, it's quite extraordinary what I could have afforded under those leases as an individual without earning huge amounts of money. You can pay for those leases, they're nominal leases, and yet you get enormous value from property. So I think, contextually, it's not hard to think of cases where nominal compensation might be yielded. I think it's far more difficult when we start talking about nil compensation. And I understand that the debates there, I've heard them not fully in the context of a legal court case, but I've read different arguments about whether it's permissible, whether it's not permissible. That would have to be argued more fully, and I think that's there are interpretive questions that need to be actively engaged.
Thank you very much. Thank you, Acting CJ.
And thank you. I have Commissioner Klaber, Commissioner Motolo Zepu, and Commissioner Lucas, and I think those would be the last ones
I had my hands up, right?
Let me. That is Commissioner Makwaneshi.
My hand was up as well.
Yes, I'm going to put it.
Acting Chief Justice.
Yes.
Acting Chief Justice.
Hang on, please.
I did not raise my hand. I was just drawing my attention to.
Okay.
Acting Chief Justice, please don't forget the people on the virtual platform.
Hang on. Is that Commissioner Schlemmer? Breitenbach.
My hand was up as well, but Commissioner Breitenbach and others online might also want to.
And Singh.
Yes. Okay. The people I've added are Commissioner Moimang, Commissioner Lucas, Commissioner Breitenbach,
Commissioner Singh and Barnard both have their hands up, Acting Chief Justice.
Commissioner who?
Commissioner Singh and Commissioner Barnard also have their hands up.
Oh, okay. Okay. I'll tell you who I've got now, and I would like us to really stop if we can now. The people that I'm going to give, Commissioner Klaber will be next, Commissioner Matolo Zepu next, Commissioner Lucas will be next, Commissioner Moiman, Commissioner Breitenbach, Commissioner Singh, Commissioner Barnard, Commissioner Schlemmer. But it's all one question, please. Otherwise, if we don't restrict ourselves and discipline ourselves, we are going to have a problem with time. Okay, all right. We still want to make sure that we do a proper job, but let's keep our eyes on the time. Commissioner Klaber.
Thank you very much, Acting Chief Justice, and good morning, Advocate.
Good morning, Commissioner Klaber.
Thank you very much. You have actually touched on Section 25.3. I would want to focus on 25.5 right through to 25.9 of the Constitution. 25.5 to 25.9 of the Constitution. Those sections are critical to the realization of other constitutional rights, such as the right to dignity and the right to have access to adequate housing.
I'm sorry, Commissioner Klaber. Is everybody able to hear Commissioner Klaber? I think maybe if you could bring your mic closer to you, Commissioner Klaber.
Thank you so much, Chair. I'm happy you have touched on Section 25.3. I'm going to confine myself to section 25.5, right to section 25.9 of the Constitution, and say those that section and the subsections are critical to the realization of other constitutional rights, such as the right to dignity and the right to have access to adequate housing. Now, my question is, what do you think has been the or have been the major stumbling blocks to the acceleration of land reform in South Africa, and how that can be overcome? Thanks.
And before you answer, Ms. Cowen, I just say, just bear in mind that while on the one hand, I do want you to address questions adequately, on the other hand, we would like shorter answers if possible. Okay.
I'll do my best, Chief
Thank
Justice.
you. Okay.
Thank you. Yes, thank you, Commissioner Klaba. The provisions that you referred to, I think, are the provisions that really give the legislature immense power, or immense scope, let's call it scope, to do a lot. We must accept that we haven't done enough. I think we need to accept that the process of achieving land justice was never going to be easy, and it's going to take us time. I think we need to accept that, but we also need to accept that we haven't moved fast enough. But we've got an enormous task on our hands. I think that there's a need for. Yes, there's a need for, I think the legislature has quite a heavy duty at the moment to really examine whether there can be some more other steps to be taken. I am aware of the recommendations that were made in the Motlanthe report, and I don't need to speak to those in detail, but there's some interesting and important ideas, especially around, I think, survey and registration, some informal systems of registration. I think they're really important ideas that need to be explored. So there's a duty on the legislature, and I think if I would, I've spoken about the need for us to build the judicial space, so I won't go back to that. Perhaps just focus on the executive role a little. I think we need to accept that our institutions are struggling, and so the Commission, we know, I think we all know, is struggling, and we need to build our institutions, and we need to strengthen them, and I think that's quintessentially an executive role. So there's duties on all of us, and I just think we need to. I think there's a quote, there's a pithy quote in the book Land Matters that says we need to take the Constitution off the shelf, dust it off, and put it to work on the land, and it's a very powerful idea. But I think we've all got a lot of work to do. We've got to expend some elbow grease.
Thank you. Then Commissioner Motolo Zepu. Thank you, Commissioner Klaba.
Okay, thank you, Acting CJ, and good morning, Ms. Cowen.
Good morning, Commissioner.
Mine is very simple. I just wanted to know whether you've removed yourself from the role of advocate, and if not, why don't you have a good standing certificate from the LPC?
I'm sorry, I didn't hear the first part. I heard the second part.
I'm saying that I want to know whether you have removed yourself from the role of practitioners. The reason why I'm asking, you don't seem to have a good standing for me to even actually consider you from the LPC.
Thank you, Commissioner. If I can answer that in the two parts that you've raised it. The first is, well, at the moment I'm straddling two roles. So I act on a regular basis in the Land Claims Court. So, but for the other 6 months of the year, I'm still practicing. So no, I haven't fully removed myself. And that, as I see it, that's not a, one has to pick a course. You can't straddle both for reasons that relate to how one, it affects your state of mind. You need to choose one course. But as I think we all know, the process of if you're going to make yourself available to the for consideration by this commission, then one has to make yourself available for acting. So the short answer is no, but I fully appreciate what that means. And I've given quite a lot of thought to the need to really shift your mindset when you stop being an advocate who advances partisan interests, and you fully immerse yourself in the role as a judge, where you have to be partisan and you have to be impartial and you have to consider things from all parties' perspectives. So I'm very mindful of that. On the good standing issue, I am in good standing. I am aware that the certificates that I supplied to this body were from the professional bodies of which I'm a member. So I supplied the commission with my certificates from the JSA and also from Habasa. That was my understanding of what the requirement was, because I understood the question to be about your professional body. I didn't understand the question to be the regulatory body. And I'm wondering if it might have been a matter of the way the form was phrased. But if I was incorrect in that, I must just apologize. But I can give you my assurance I am in good standing and there are no disciplinaries against me. I've never been informed or notified of any complaint.
Thank you, CJ. I don't want to pursue that, but I think you need to verify that we are a practicing practitioner.
I'm a member of the LPC and I have my number. Yes, I am. I've paid my dues throughout. And I'm supportive of the work of the LPC. I am a member, got a number, paid my dues.
Okay, all right. Thank you. Commissioner Lucas.
Thank you very much, Acting Chief Justice. Good morning, Advocate.
Good morning, Commissioner.
I have a question. In all the restitution cases, particularly the governance arrangement of post-settlement, has been very challenging. That was our experience in the province, and I'm also seeing it in some of the areas in Northwest where I am currently working. What advice would you give to the Minister of Land Reform as to regards the governance arrangements of post-settlement cases? Thank you.
Thank you, Commissioner Lucas. I think that's an incredibly important issue, and I've seen it in practice. I've seen it in the Komani San matter where I was engaged in the post-settlement disputes. So I've seen what happens. The issues arise. The advice I'd give in short is that, and it would be advice to the minister. I think that's the correct target of the advice. Is that it's not only to the minister; it's also to the profession, because we need to think about our role as lawyers. The advice I'd give is that we need to think carefully about how the legal instruments that we use, which is typically communal property associations or trusts, what should those instruments look like? How do we draft those instruments in a way that foreshadows and anticipates problems that we know are going to arise and that are inevitable? So in the Komani San matter, there were questions around membership. Who is a member? And how does that work with ascendancy, when one thinks about ascendancy and descendancy in connection to the dispossession? What is the community for purposes of that restitution? And it's hard to get it right. One needs to think very carefully and in great detail about what the practical mechanism should be to ensure that if a dispute arises, you can resolve it in a peaceful and non-litigious way. There's also issues around capacity. So sometimes you don't solve the problem by creating a structure to hold ownership for a community. That's not going to solve the problem. You need to spend a lot of time thinking about what that instrument looks like and how it's going to cater for the specific needs of that community. Because every community's got its own dynamics and its own history, its own colonial apartheid history, its own history in multiple ways. So I think we need to, both as practitioners, and I think it's a function that the executive could well pick up, really think about how to strengthen those processes. It's not easy, but it's possible.
Thank you.
Thank you. The next one will be Commissioner Moimang.
Acting Chief Justice. Good morning, Advocate Cowen.
Good morning, Commissioner.
The dualism in land ownership in our country remains a challenge between the urban and the rural poor. What is your view on the interest of traditional leaders that hold a bit of a grip on the ability of those that found themselves living under communal land areas to be granted certificate of ownership so that they can also enjoy the rights of ownership as the urban contingents? Thank you.
Thank you for the question, Commissioner. This is an issue that I've grappled with in a number of occasions during my practice, and if I can try and put my view simply, it's this. On the one hand, our Constitution recognizes traditional leadership and gives it a place, an important place in our constitutional dispensation, and we have to understand that and work with that. My understanding of what I've encountered in practice, let me put it that way, so far, is that under customary law, the typical arrangement is that, or the typical principle is that once allocated, land vests with a family, typically a family. I'm talking about, so land in the tillage area immediately around the land. There are different considerations around grazing, often in the rural context, but that the vesting of that right, the right that vests is very powerful and it's akin to ownership. There are questions around alienability that we have to look at those subtleties. But my understanding is that that our law actually does give expression, and obviously the case, the Ngunyama Trust case, the recent Ngunyama Trust case deals with this. I think that we need to recognize the power, the strength of customary law rights in that's in the rural context. In the urban context, again, I mean, we're dealing with very fragmented systems. Traditional leadership operates more strongly in the rural areas and in the former homeland areas. But in the urban context, I think we need to appreciate that our systems of tenure are quite fragmented and complicated, and again, we need to find ways to secure tenure. That should be my short answer.
Thank you. But there's no security of tenure in communal to the communal to the people that are living under communal land. There's no vesting that has taken place. It remains in trust with the Minister of Land.
In the Northwest?
Across the country as a whole.
In many places, I think that's true, Commissioner, and in the Northwest, it's especially true. I think that there's the tenure systems and the trust systems, as I understand it, are very strongly premised in a situation where there's both the minister holding a trust and the other trust forms as well. And yes, I think that renders land tenure, it renders security, land security insecure. It's insecure. That tenure is not secure. I think that's correct. And it's not necessarily, what I'm saying is that it's not necessarily because the customary law rights aren't strong in law, but it's because our systems haven't grappled with the interrelationship between those systems and the traditional leadership adequately.
Thank you, Advocate. Thank you, Acting Chief Justice.
Thank you, Commissioner Moimang. Commissioner Breitenbach, your turn.
Thank you very much, Acting Chief Justice. I was covered by Commissioner Lucas.
Thank you very much. Commissioner Singh, your turn.
Thank you very much, Acting Chief Justice. Good morning to you and to the commissioners and to Advocate Cowen. Advocate Cowen, I just want to agree with you when you define land justice as a critical social and legal issue. Now, the problem that we find on the ground, and I just like your comments, is that with the land issue, there are fears and there are aspirations. Fears that those whose land has been claimed, that the land will be taken away from them at some stage, and then they don't develop the land adequately. And the aspirations of those who have lodged claims. Now, I'm saying this in the background of the fact that there are almost 10,000 claims that have been lodged that have not as yet been even assessed for prima facie evidence that those claims really do exist. Now, I do understand that your court only deals with disputes. But you spoke about the challenges earlier on, and you spoke about dialogue. And you also spoke about the role of the executive. Who do you think should fire the first salvo in this, in ensuring that there's dialogue between those of you that sit at the court level and the executive? Because that is going to sort out a number of problems and unnecessary tensions that exist on the ground. Thank you.
Thank you, Commissioner Singh. I'm not sure that I could answer your question. Who should fire the first salvo? I don't think we should think of it as a salvo. I think we should all commit to participating in a constructive dialogue. So I think that there are different circumstances in which warrant different arms of government to take the initiative. So there will be times when the executive needs to step forward and say, we need to discuss this. And there'll be times when the judiciary needs to step forward and say, we can see this problem, let's discuss this. So I don't think there's a short answer to the question. And I also think we need to think of it as constructive engagement within the context of a separation of powers. I hope I've answered your question.
Thank you. Perhaps the JP will give us some answer to that later on to see what he has done. Thank you, Acting Chief Justice.
Thank you, Commissioner Singh. Commissioner Barnard, your turn.
Thank you. Good morning, Acting Chief Justice and Acting Judge. My question deals about the land transactions and eviction legislation. So it's just simply a question is how should one or the courts deal with the fact that certain legislation like the Alienation of Land Act, Esther, and the Rental Housing Act, they all have sections which exclude, the possibility of contracting out of them. So it's specifically set out. Whereas if one looks at the PI Act, Prevention of Illegal Eviction and Unlawful Occupation of Land Act, it doesn't contain such a prohibition. So the question is, what should one do, make of that, bearing in mind constitutional interpretation and the protection of the right to housing? So is the section which prohibits contracting out of the eviction, the absence of it, what relevance should be attached to that? How should one deal with it? Thank you.
Thank you, Commissioner Barnard. Well, again, I need to be cautious because questions around privity of contract can come before the court. So, and an agency, including contracts, are issues that can emerge as live disputes. So, I need to be cautious in how I approach my answer. But also at a high level, I think that the way we need to think about land issues, both in the urban, but land claims court focuses on the rural context, is by appreciating what is a fundamental power imbalance that flows from the economic and social impact of what was ultimately a crime against humanity. And I think we need to understand that choice in that context, we need to deal with it carefully.
Thank you very much. Thank you, Acting Chief Justice and Judge.
Thank you. And then it's Commissioner Schlemmer.
Thank you, Acting Chief Justice. Good morning, ma'am.
Good morning, Commissioner.
You've spoken to us a lot about the land issues and expropriation a little bit, but I would like to know what your judicial philosophy is when you sit on the bench.
Thank you. Well, I suppose the way I think about it, judicial philosophy is obviously a very large question and a large subject that invokes all sorts of ideas, but fundamentally, I think we have to ground ourselves in the rule of law. That's what we're dealing with fundamentally, is the place of the judiciary in the rule of law. And that obviously requires us to think about the separation of powers in most of the things that we do. So we have to ground ourselves in those principles of the Constitution and obviously in the protection of rights. That's central. When that comes to the adjudication of disputes, I'm not formalistic in my approach. I think that under the South African Constitution, we enjoined to and obliged to give real meaning to the Constitution, and that's a process that requires a level of, I wouldn't call it activism, but it requires a process of giving. You have to give content to values, and that means that you have to engage actively with what are the social norms, what are the realities on the ground, what are we dealing with. So my philosophy is that you have to, we can't approach law myopically, we have to approach law contextually, purposely, and ultimately with a view to giving, to achieving the objectives of the Constitution, which are fundamentally transformative.
Thank you, Commissioner Schlemmer. I think that was the last commissioner to ask questions. We've come to the end of your interview, Ms. Cowen. Thank you very much for availing yourself. You are now excused.
Thank you, Acting Chief Justice.
Thank you.